So what I will do today, Mr. President, I will not read the committee report, that it is rather long and voluminous. I will just go through the main findings of the report so as to give the senators a good idea about the discussions and the logic behind the conclusions at which we have arrived. The Committee on Local Government had arrived at have made 6 findings. So let me go through them in turn. First finding is that the appointment of the officers in charge by the President is contrary to the principle of autonomy which is guaranteed by the Constitution. Mr. President, it is clear that ARMM autonomy is mandated by Article 10, Section 1 of the Constitution, wherein where it is stated that the territorial political subdivisions of the Republic are the provinces, cities, municipalities, and barangays, and that there shall be autonomous regions in Muslim Mindanao and the Cordilleras as hereinafter provided. Furthermore, in Article 10, in Section 18 of Article 10, that the Organic Act shall define the basic structure of government for the region, consisting of the Executive Department and Legislative Assembly, and most importantly, both of which shall be elective and representative of the constituent political units. The argument that is made is that the President has the power of general supervision over autonomous regions, and therefore this is sufficient, perhaps, to allow the President to appoint OICs in a holdover capacity should the ARMM elections be cancelled. However, the President's power of general supervision in our finding is that precisely for the President to ascertain and to make sure that the officers and the officials and all the entities in ARMM are precisely following the law as it has been written, not to change it. The power over general supervision over LGUs and autonomous regions does not cover appointment and removal of elective officials. And furthermore, Congress may not pass a law increasing the President's power of general supervision. It is the view of the DOJ that the power of the President to appoint interim officials may be justified under appointment authority of the President under the so-called residual power. And ironically enough, the quoted case is Marcos versus Manglapus. Furthermore, the Department of Justice's opinion that the statutory provision on the appointment power of the President of armed officers in charge is unnecessary. However, it is our view that this does not apply in this particular case because the exercise of residual powers by the President to appoint is done in the case of a vacancy of an elective position. A vacancy because of death, because of retirement, because of illness, and that is when those residual powers are exercised. However, in this case, we do not believe that it applies in this case. What is happening is that the 2 bills invoke the President's so-called residual power by deliberately creating the vacuum through the postponement of elections. So it is still within the same measure that gives the President the power to appoint. It is also creating the vacancies which is now claimed to give the President the power to appoint. Hence, it is our view that it is unconstitutional and contrary to law. Finding number 2, House Bill 4146 and Senate Bill 2756 in effect amend Republic Act 9054 and do not merely amend Republic Act 9333. It is argued that the 2 bills merely seek to amend Republic Act 9333, which has not been subjected to any plebiscite in any of the postponements that we have before. However, it is the view of the committee that the 2 bills do not merely seek to amend RA 9333 as expressly declared in their titles, but they ultimately seek to amend RA 9054. A statute and its amendment should be read together as a whole. The amendment becomes a part of the original statute as if it had always been contained therein. That is why it is our belief that it is in fact an amendment of the organic law. If that is the case, then although a two-thirds vote was attained in the House of Representatives, there has never been any plebiscite in any of the postponements that have been done in the ARM law under RA 9333. However, the fact that RA 9333 was not submitted to the people for a plebiscite in 2004 cannot be considered as a valid precedent. And besides that, if we accept this position, there is no longer enough time for us to conduct a plebiscite in time for the 8 August elections, because plebiscites should not be held any earlier than 60 days or later than 90 days after the approval of such amendment or revision. Finding number 3, the reforms in ARM can be effectively instituted by officials to be elected by the people on August 8, 2011. It is our view that the reforms may still be achieved without necessarily negating the people's right of suffrage. Number 4, the mandate through an electoral process is a fundamental element of democracy and autonomy. Any planned reform should be pursued in accordance with the principle of democracy and autonomy. This is the essence of the long-standing doctrine that ours is a government of laws and not of men. It is highlighted further by the fact that what we are talking about is the cancellation of elections in an autonomous region, the autonomous region of Muslim Mindanao. We had posited several times to those that had come before the committee, what would have been the effect if the President and the House and the Senate would then put through legislation through Congress. And we are saying that to any region, aside from ARM, and we will tell that region, your elections are now cancelled, and in lieu of those elections, we will appoint the officials to elective positions. That is entirely unacceptable to any region, any province, any local government unit in the Philippines. Much more so, I believe, in what is referred to and described and recognized as an autonomous region. And that is why it is highlighted particularly in this case. Number 5, the main reasons for the postponement of elections either have already been corrected by COMELEC or are within the power of the national government to guarantee. In the hearings that we conducted, we asked, not only here in Manila but also in Marawi City, we asked the COMELEC as to their preparedness for this election, and if they had done all the things that needed to be done to answer the criticism that the electoral process in ARM is highly flawed and is subject to abuse. Many of the voter rolls are greatly suspect. They reported to the committee that in fact 90,000 names have already been deleted from the rolls of ARM voters for the simple reason that some of them did not exist, some of them were named twice, some of them do not come from ARM, and for various reasons. Furthermore, they also reported to us that the process of gathering biometric data from each of the voters is 85 to 90% complete.